Could I just remind everybody that there is a reporting restrictions order in this case. The court orders that no one shall publish or reveal the name or address of the appellant who is the subject of these proceedings, or publish or reveal any information which will be likely to lead to the identification of the appellant or of any member of his family in connection with these proceedings. I always think it's wise to remind the court of that, because these proceedings are live streamed, and so any slip is irretrievable. Thank you. Mr. Setrak.
May it please my ladies and lords, in this appeal I appear on behalf of the appellant D, instructed by the official solicitor, together with my learned friends Mr. Alex Rutke, Mr. Michael Gratian and Ms. Annabel Lee. The respondent local authority, the Birmingham City Council, is represented by my learned friends Mr. Richard Gordon, Queen's Counsel, Mr. Jonathan Cowan, Ms. Anita Rao, and Ms. Eleanor Sibley. And there are two interveners. The first intervener, the Equality and Human Rights Commission, is represented by my learned friend Mr. David Wolfe, Queen's Counsel, and Ms. Victoria Butler-Cole. And I said there were two interveners. That's my first mistake.
Is it four?
I think there are three. I think, because there are two Secretaries of State.
I thought there were three Secretaries of State who were interested.
I think there might only be two who are
I think we
here.
have Justice, Education and Health.
Yes, I think that it's Education and Justice who are here, yes. But I'll be corrected if I'm wrong.
Well, this may be the case, but in any event, Sir James has got health's interests also at heart.
Yes, health is engaged. And shall I say that the government is an intervener and represented by my learned friend Sir James Eadie, Queen's Counsel, together with Ms. Joanne Clement and Mr. Jonathan Orban. My ladies and my lords, I draw the court's attention, if need be, to a slight anomaly in the numbering of the MS page numbers. They start for a reason which relates to the late arrival of one of the interveners with the authorities. So the core bundle unusually starts at MS 2997. But I don't anticipate that that is likely to cause any...
As long as you know what the number is that you want to refer us to, we don't mind what that number is.
Well, let's see if I get it right, my lady. The timings are in the usual way, all agreed between the parties. The only other matter that I mention is that depending on where we get to in the oral submissions, I may put in, seek to put in an additional authority. That has been distributed at the bar. We will provide copies if appropriate. So, in that event, let me come to the case for the appellant. The statement of facts and issues obviously contains all the background material, and therefore I'm not going to take up the time of the court with anything more than the baldest summary that this case concerns D, 17 at the time of the hearing before Mr. Justice Kean, which started the litigation process off, now aged 19. He has ADHD, Asperger's, Tourette's, and a mild learning disability. His parents tried and were unable to care for him at home. At the time of the hearing before Mr. Justice Kean, he was confined in a residential placement arranged and paid for by the respondent. He lived behind locked doors. He was provided with one-to-one support throughout the day. He wasn't allowed out unaccompanied. He'd absconded from a previous placement, seeking to return home, and an alarm had been placed on his bedroom door. There's never been any debate between the parties, or indeed the interveners, that this was the right place for D, or that the restrictions were other than necessary, nor in this case has there ever been any controversy that his parents were entirely well-intentioned in agreeing with the local authority that he should be accommodated there. So it's common ground that he, however, didn't have the ability to consent to the restrictions placed upon him himself. The debate has always been whether that means that he should be regarded as being deprived of his liberty. The issues in this case, again, without going into detail because the court has the statement of facts and issues, are, apart from this litigation, unprecedented. They were so identified by the Court of Appeal. The submissions before Mr. Justice Kean, put forward by the official solicitor and Mr. Rakeen, were novel, and the late official solicitor, Mr. Alistair Pitt-Blado, saw this as a case of considerable importance to which he had a personal commitment. And he took an interest up to and including the drafting of the application for permission to appeal. His death occurred very shortly before, a matter of days before leave was granted. And we're instructed to advance this appeal so that this court has placed before it choices as to how the common law, essentially, should be shaped in 2018 to deal with cases like these. Critically, those choices will also affect the basis upon which care and treatment is provided to those such as D. And we are going to submit that the court will need to consider how to address the requirements of three classes of actors. First is the cohort of children between the ages of 16 and 18, whose disabilities mean they have needs for care and treatment to which they cannot consent. Second cohort, the professionals who have to deal with those children in a variety of circumstances. And the official solicitor, and if I can slightly personalise it to my learned junior, Mr. Rakeen, who writes and teaches on the subject extensively, are very conscious of the need for clear, reliable advice to be given to professionals who may have to deal with difficult situations with great urgency. And the third cohort is, of course, the parents of those children who will be seeking to help their children, again, often in anxious circumstances, and almost always those parents will be operating with those children's best interests at heart. But it is, unfortunately, undoubtedly conceivable that there are parents who will not place those children's best interests at heart, but will be influenced by other factors. So we say that there are essentially four choices for this court in shaping the common law. And they bracket the positions of the parties today. The official solicitor's primary case, we plainly want to set out alternatives to give the choice to the court. The primary case, which starts with the child as an independent legal actor and of necessity, whilst in no sense devaluing the views of parents, which will continue to be given weight and continue to be taken into account, nevertheless renders them in law unable to consent on their child's behalf to care, treatment, or confinement. So that's the primary case. Then there's the alternative case, which retains the ability of the parents to consent.
Is that the second choice?
Yes. But nevertheless expects them to apply, with their conduct subject to a professional overview, the closest analogue possible to the best interests test contained in the Mental Capacity Act 2005. So 2005 Act safeguards grafted onto a retention of parental consent. And the third is updating the language but not the substance of the common law. The fourth, which we mentioned because although we don't think anyone is advocating this, we'll come to that in our submissions, theoretically, no change at all to the current situation. And we say that on looking at the written cases of the parties and the interveners, no one quite advocates no change.
What do you mean by the current situation? The situation is laid down by the Court of Appeal.
Yes, we say, and I don't want Milady to distract myself by going in at this stage to what the Court of Appeal said, but we say that there is limited guidance from the Court of Appeal in its judgment over what in practical circumstances should happen. My ladies and my lords, we have, which rather flows from what I just said, a very great deal of ground to cover in these oral submissions, and plainly I must keep to my time limit. We won't, therefore, remotely be taking the court line by line through our written case, because we've now got substantive cases, particularly from Birmingham and from the government, and responses from us at this stage to them and arguments to be advanced are plainly required. And so what we're going to do is to follow the sequence of the written case, but only make relatively infrequent visits to passages in it, because we anticipate that my ladies and my lords have read the document, and repetition in this court isn't usually a particularly effective method of advocacy.
You are completely accurate in that statement.
So far.
Whether it's the most accurate statement you'll make in the course of the hearing, I know not.
I'll avoid truisms as well then, my lady, if I can. And so we don't also seek to duplicate, following a discussion, the submissions made by the Equalities and Human Rights Commission, which are broadly complementary with our case. The points we do say, although we in large measure don't agree with the Secretaries of State, we are very grateful that the Secretaries of State have intervened, because it allows an effective discussion and consideration of the choices before the court. So hopefully that approach will leave our true reply as a true reply, principally to matters emanating from oral submissions. One matter which we should deal with immediately is the extent to which the official solicitor's case stands or falls on the Mental Capacity Act 2005. Both Birmingham and the Secretaries of State characterise the official solicitor's case as being predicated upon an assertion that the Act in and of itself curtailed parents' pre-existing common law powers, and they then seek to answer that case by the simple means of saying that a review of Hansard demonstrates that the Parliament didn't demonstrate an intention so to do when passing into law the Mental Capacity Act.
And they also say there's nothing in the Act which does it.
Yes.
That's more important.
Well,
Rather more important than what's said in Hansard.
Just so, that's another matter. But clarifying what our case advanced before the court today is, we make it clear that we readily accept that Parliament in enacting the Act didn't itself expressly abrogate prior common law rights enjoyed by parents across the board and for all purposes. Rather, we say the existence and effect of the Act, and it exists and has an effect whatever Parliament's intention had been, its existence and effect as a statute currently in force provides part of the context in which the common law rights of parents are, we suggest, to be reassessed in critical ways which we will develop in these submissions. Before we come to those submissions, what I'm going to seek to do is to summarise what we understand to be the common ground between the parties and the interveners. And we see 6 areas of common ground. First, when we refer to parents in this context, we are talking solely about individuals, individual persons. So, for example, a local authority with a care order under the Children Act 1989 has parental responsibility. There's agreement that we're not talking about corporate holders of parental responsibility. We are referring to individuals. Therefore, children's natural parents who are so enfranchised and other individuals who are so enfranchised, we think that special guardians are an example. The second...
But on what, you say that's common ground, but actually that's highly contestable.
But whether it is contested between the parties is...
Well, as far as we're concerned, we want to get the right result, whether or not any of the parties want it.
Well, then, that's why we have outlined what's common ground, as we understand it, in the parties before the court. But by highlighting that, yes, my lady, with great respect, might reasonably say, well, why?
If what we're talking about is what the common law of parental responsibility is, and local authorities have parental responsibility by virtue of a care order, why shouldn't the same apply to them?
May I come to that in due course?
You don't have to if you don't want to.
Like many things in this case, my lady, I'm going to be very easily tempted to deal with matters of real interest, and that is one of them. But I've probably got to keep to my burrow at the moment. But, my lady, I will come back to that if there is the opportunity, because with respect, I agree, it is an important question. The second area of common ground, at least between the parties, is that in any given situation, a person seeking to take action in relation to the 16 or 17-year-old in question will need to know the basis upon which they are acting. That's the reason why this is important. The third is that whether a 16 or 17-year-old can themselves factually consent to an act of care or treatment should be approached on the same basis as whether they can consent to their confinement. There are those two areas, they are distinct areas, but in this respect, there isn't a distinction. Fourth, it's not a question of whether the rights and interests of cognitively disabled 16 and 17-year-olds should be both safeguarded and where necessary, prioritized vis-à-vis their parents. Not a question of whether, but how. And that brings us back to our suggestion that nobody in this case is really suggesting that things should be left entirely as they are, without, at the very least, some careful definition. And fifth, whilst the Secretaries of State in Birmingham say that they espouse the current arrangements, flows from 4, on a proper analysis, we say that no party or intervener suggests that the common law should be left entirely untouched. It's not been looked at, we say, by this court or the House of Lords since 1985, and we provide an example. The Secretaries of State submit in their analysis of the Looked After Children framework, and I can give the court a reference, but I'm going to read the passage out so there's no need to go to it, that a, quote, parent must seek and obtain professional advice before providing consent to arrangements that amount to a confinement. I'll read that again. A parent must seek and obtain professional advice before providing consent to arrangements that amount to confinement. That's MS 3223, paragraph 63. We say that there is at the moment no clear indication that there's any statutory basis for that obligation upon parents. It could only derive, therefore, from the common law, but again, the common law derivation is not an obvious one. So if the alternative route is to load responsibilities of a formal nature onto parents, query, how is that done? And what should those responsibilities be if the interests of this particular cohort of children is to be adequately protected. So we say that having identified those areas, the real question may well be the extent to which this court should shape or define the common law. And essentially, the difference between the parties and the interveners is that Birmingham and the Secretaries of State appear to submit that it's possible to adjust the common law whilst leaving parental consent intact, whereas the official solicitor submits that is not, in his primary position, not adequate to ensure that decision-making starts with the child as an independent legal actor and then works upwards and outwards. We say that only by rendering it common law, parents, while continuing to have a right to express their view, which can be heard and carries significant weight, so this is by no means an attack on parents, that they will nevertheless be substantially unable to consent to the relevant acts. Only by doing that can this be achieved. In the event that the court doesn't agree with that position, then what we're going to do in our written case and this morning is to set out a framework to seek to ensure that the common law is taken as far as possible to secure the interests of the child within the framework of parental consent continuing. So with that rather longer introduction than I'd hoped, may I turn to the primary case of the official solicitor. And we adumbrate some factors which we invite the court to consider that are relevant in determining how far it should go in considering the shaping or reshaping of the common law. The first question, and I'm going to come to these in turn, but if I give the headlines now, the structure of these oral submissions will be clear. The first question, which is a basic one, is why do parental rights exist at common law in this context? The second is what factors can this court take into account when deciding upon the approach, its approach to the current common law. The third is a more confined and technical question. What does confinement look like? Because the principal concern in these cases, of course, confinement. What does confinement look like in relation to a 16 and 17-year-old? The fourth is, should the law in 2018 disallow a parent from being able to consent to the confinement of a 16 to 17-year-old who lacks the ability to consent to that confinement? Well, that's perhaps the key question, so putting it in that way may not add much, but that's a stage we're going to go to. Fifth, what relevance do statutory provisions in relation to looked after children have? Because the court will have discerned that both Birmingham and the Secretaries of State spend relatively considerable space in looking at the looked after children provisions on the basis, I think, that those provide an adequate background of safeguards. And finally, six, how should decisions in relation to care and treatment of 16 and 17-year-olds with impaired capacity be taken? In looking at those questions, we come at once to Strasbourg authorities, or we rather say the lack of helpful, relevant Strasbourg authorities.
Well, there's one very difficult Strasbourg authority, is there not?
That we have Nielsen.
Yes.
Yeah, precisely so. Nielsen is obviously in the authorities. I'm not going to take my ladies and my lords to it at this stage, but the reference is Volume 1, Tab 6, MS 262. But we say that Nielsen, addressing a different age of child, a different factual context, but primarily directs those who read it with an eye to gleaning assistance from it, not surprisingly directs the reader inexorably to the domestic law of the relevant state. And so there isn't really an escape by looking at Nielsen from the questions and the conundrum that is before this court. Because we think, after pretty exhaustive research, and that research has also gone to looking at the domestic practice and law in some other jurisdictions in the time available, we have been unable to find anything else that is likely to help the court. And we say that Nelson doesn't really help the court to any great extent. So we say that if one is driven back by Nielsen to the domestic law, and Nielsen is a difficult case, and we've seen what's been said in Cheshire West about it, that to which we may come, at least fleetingly, that one is driven back to the current state of the English law. So having indicated to my ladies and my lords that we certainly haven't forgotten Nielsen or Strasbourg, we hope we can be forgiven for going now to our questions. Why do parental rights exist at common law in this context, the context of the issues in this case? We say that that is a basic question. It frames everything that follows. And what we do, inevitably, is to go back 33 years to 1985 and the celebrated case of Gillick. I am going to take my ladies and my lords to that authority. And so this is Volume 1, Tab 4, MS 124. 124.
124.
I hope. And I'm first going to take the court to what Lord Fraser said. I'm not going to take up time describing Gillick, though I could. It's very well known even today, and I don't think you have to have the age and long memory of this particular advocate to have a vivid recollection of what it was all about. But if I take the court to the speech of Lord Fraser at 170D, that's MS 182, there's a critical observation, we say, and it's a short passage, so I'm going to read it. It was, I think, accepted both by Mrs. Gillick and by the DHSS, and in any event I hold that parental rights to control a child do not exist for the benefit of the parent. They exist for the benefit of the child, and they're justified only insofar as they enable the parent to perform his duties towards the child and towards other children in the family. Looking back to ancient authority, relatively ancient, 1830, there it is in Blackstone. So it is, says Gillick, it is justifiable only to allow the parent to perform duties towards the child for the benefit of the child. Then, if I may, I will take the court to Lord Scarman at 184F, and that is MS 196. And it's another relatively short extract. Secondly, there's the common law's understanding of the nature of parental right. We're not concerned in this appeal to catalogue all that is contained in what Lord Justice Sachs has felicitously described as the bundle of rights. I remind myself that the concept of the bundle of rights has carried through in English law up to the advent of the Chiltern Act, which together constitute the rights of custody, care and control, and then the key observation by His Lordship. It's abundantly plain that the law recognises that there is a right and a duty of parents to determine whether or not to seek medical advice in respect of their child. I'm going to pause there. So that's an identified right and duty to determine whether or not to seek medical advice.
Have they got a right not to seek medical advice, given that it's a criminal offence if they don't?
In the common law unencumbered by the criminal law, perhaps the argument would be, being not the devil's advocate, because I can't categorise those at that end of the table so, but looking at the way it's being argued, the parents would have to make an analysis in which they'd have to look carefully to see what the benefits and disbenefits of seeking medical advice were. But arguably, if there's a right and a duty to determine whether or not to seek medical advice, then they've got a duty to look at the question. It may well be that at the end of that process, they will decide not to seek it. But that is a self-contained right and duty. With great respect to my lady, the criminal law may mean that some decisions taken not to take medical advice may be unlawful. The question, of course, may be how, in utilitarian terms, that will actually work when one has an internalized decision-making process in the mind of a parent. That parent may be, and in the vast majority of cases will be, sensible and well-attuned to the needs of the child. There may be some cases where for all sorts of reasons that simply isn't so. But travelling on...
Sorry, I'm not quite sure what your answer to my lady's question was. I mean,
taken all together, it is possible for a parent not to exercise the right, but there may be penalties for so doing.
And, of course, there is the power of the state to intervene to protect the child, which is even more important.
If it finds out.
This is why it's so difficult, isn't it,
yes.
to distinguish between the common law without the intervention of statute, and there may even have been a common law offence.
Precisely so, lady, with great respect.
Yes, somewhat equivalent to Section 1 of the Children and Young Persons Act 33.
So the court can see where we are heading with this reference. But the next phrase, and having received advice. So the first duty is to decide whether or not to receive advice. So if they decide that they are going to elicit and receive advice, to give or withhold consent to medical treatment. So that's what was said by Lord Scarman. Though he goes on to say the question in the appeal, this is Gillick's case, is as to the extent and duration of the right and the circumstances in which, outside the two admitted exceptions to which I've earlier referred, it can be overridden by the exercise of medical judgment. And that indeed was what the case of Gillick was to a great extent about. So we say that it's clear that, with respect, that parental rights exist as a corollary of duties imposed upon parents, as much as a matter of moral and legal obligation to secure their child's interests. And the unasked question, unasked in Gillick, so far as we can discern, is why is it necessary for a parent who's complied with her or his duty to seek medical advice, an unequivocal duty, then to be a giver or withholder of consent to the recommended treatment? So we make a disjunctive between those two phrases of Lord Scarman. If, as we seek to demonstrate, it is now possible, post the enactment of the Mental Capacity Act, to provide treatment to an incapacitated 16 or 17-year-old absent the consent of a parent, and it is with respect, and indeed notwithstanding and in the face of their refusal to consent, then it's clear that the linkage, if there is a linkage referred to by Lord Scarman, that was once necessary between parental duty and parental right to consent, has been broken. Or putting it another way, it is plain, we say, that the Mental Capacity Act is a changing ingredient in the landscape of parental rights, their exercise, parental responsibilities, and the rights of children in these circumstances. And at one level, we say, although that doesn't simplify a complicated consideration, that's what this appeal may be all about. It's the consequences if that linkage is broken, and if the if the Mental Capacity Act makes a difference, it's the consequences of the breaking of that linkage. But let us first turn to the challenge which is mounted by Birmingham and the Secretaries of State, which is in effect that the common law must broadly remain as found by the House of Lords in Gillick, which takes us to the second question. What factors can this court take into account when deciding upon its approach to the common law? We say that But
the whole point about Gillick was the extent to which the child's autonomy took over from the parental rights and duties. That was what Gillick was all about. And there is stuff in Lord Scarman's judgment, speech at least,
yes,
which says that, well, if the child acquires autonomy, that includes the right both to consent and to refuse consent. You're coming on to that, presumably.
Sadly, the court hasn't heard the last of Gillick.
Oh, not sadly.
So we go to the factors which we say the court can take into account, and we do say that they can include, as well as, of course, the background of authority, which is the foundation of the common law, relevant domestic statutes, whatever the intention behind the enactment of those statutes, if they are extant and in force, international human rights obligations, and what we call soft law, like codes of practice, of which there are numbers in this field, and broader societal or social trends. Now, the Equalities and Human Rights Commission will address you on the way that the common law responds to international human rights obligations, but we say that an example can be found in the 2015 appeal in Montgomery, which we find at Volume 5, MS 15, tab 80, Volume 5, tab 85, MS 1539, and we'd particularly like to take the court to paragraphs 76 to 81, and that's MS 1569 to 70, of the judgments of Lords Kerr and Reid, and in particular at paragraph 81 to the reference to an unincorporated international instrument, the Oviedo Biomedical Convention. I'm not going to read those passages out, but that is the simple point which we wish to draw from the reference. There is also reference from paragraph 80 to, as it's put in the second line halfway through under 80, under the stimulus of the Human Rights Act, the courts have become increasingly conscious of the extent to which the common law represents fundamental values, and there from just above F onwards, reference to other instruments, including the Oviedo document. And a conventional, if I may say so, with no disrespect to their lordships, conclusion at 81, that the social and legal developments, so not just legal but social, which we've mentioned, point away from a model of the relationship between doctor and the patient based on medical paternalism, etc., and a restructuring of the relationship. All that, I hope, is more or less a given in terms of the approach of the court to these matters. We say that the 2005 Act forms part of the context in which this court can consider the common law in two vital respects. First, the test to apply to determine whether a 16 to 17-year-old can, in fact, consent to a relevant act. And second, if the court accepts our premise as the mechanism breaking the previously necessary linkage between parental duties and parental rights in this context. And looking at the first of those, the test to determine capacity to consent to a relevant act, and there are two classes, care and treatment or confinement, on the part of a 16 to 17-year-old. The official solicitor submits the test is now that set down in section 2 of the 2005 Act. The 2005 Act is basic material, of course, to this case. In some respects, we say it may be convenient to the court to look at paragraph 10.1 of our written case, which is MS 3101, where we set out the provisions and editorialize at least mildly upon them. I suspect that my ladies and my lords are familiar with the basic provisions of that Act in this context. And so unless the court wants us to go through them in detail at this stage, I simply invite the court to refer to our paragraph 10 and read it through, and there in particular we deal with section 2 and section 5 being the indemnity section.
Yes. How would you sum up the difference, if there is a difference, between the test of competence laid down in Gillick and the test of capacity laid down in the Mental Capacity Act? Because that's the crux of what you're talking about, as I understand it. So perhaps it would just be helpful if you could sum it up in a sentence, what you think the difference is.
We are going to...
Oh, are you going to come back to that?
We are going to come back to that. But I will...
No, if you can come back to it, don't...
I'll invite Mr. Ruck-Keene to do that task, because it's always helpful to provide a one-sentence summary, if it is possible. And sometimes, my lady, advocates are constrained from doing so by their brief. But I will try. Can you do that? So let me continue, but I promise to
Mr. Setright, before you do that, what I had understood from the papers was that it was because of the words because of an impairment or etc.
Yes.
Is that right?
Right. And also there's a presumption.
Yeah.
I think it can probably be condensed into a sentence along those lines, even though we haven't done so.
Well, that was my understanding as well, but I thought I'd better get it out.
Yes.
Yes.
I'm grateful, Mary. So let me let me continue. I suppose, having invited the court to cast a refreshing eye over 10.1 and 10.2, 10.3 in our written case may also be helpful, referring as it does for completeness to section 6, but that is really background principally. So, my ladies and my lords, the local authority and the Secretaries of State say that the test to determine capacity to consent to acts in connection with care or treatment remains Gillick competence, or at least both Gillick competence and 2005 Act capacity. And the use of those different phrases, those different terms, competence and capacity, draws one inexorably, although perhaps without any very productive result, to the use by the learned president of the term Gillick capacity, which is found by way of example at paragraph 83 of his judgment at MS 3262. That was plainly a deliberate choice on behalf of the president. Contextually, what he says in the judgment makes it clear that it is not a slip of the tongue. It wouldn't be with a prepared judgment of this detail and care. But is Gillick capacity different from Gillick competence? Well, none of that is really explained, and all of the parties and the interveners before this court don't seek to enter that area. We're not sure that it is very helpful so to do, but there it is. We draw the attention of the court to it. It's relevant if one is perhaps looking to see whether Sir James Mumby did move the common law and Gillick considerations along. If he did, it's very difficult to see how he did it.
But there's one passage where he puts competence stroke capacity.
That's right.
So
yes.
Aligning them.
Yes.
So are we to proceed on the basics that Gillick competence and Gillick capacity are synonymous for present purposes?
That's almost an inevitability, we say, absent any evidence that the president thought there was a distinction. But we wonder why use the different term unless it is sought to elevate or transfer the Gillick concept into something slightly different, in which case it may be problematic.
So where does the word competence come from? We talk all the time, we family lawyers and medical lawyers, about Gillick competence.
Yes.
But does it come from the case of Gillick? Or does it come from commentators on the case of Gillick? And do those people, have they addressed their minds to what distinction there might be? Other than the two obvious ones, which was the disorder threshold and the burden of proof.
Competence is is a very well-established term which was used, for example, in respect of witnesses. But your ladyship has raised another fundamental question. May we look at that and come back to see if we can provide an answer as to derivation?
It might be helpful. Yeah, thank you.
Thank you, my lady.
Or it might be a complete red herring. It's very difficult to tell in this case.
Only the court can finally discern that. But we quite appreciate that some fundamental consideration of fundamental concepts may be entirely appropriate when looking at the unprecedented nature of the conundrum that's placed before this court, which is also important. We say it's perhaps easiest to summarise the official solicitor's arguments by reference to the way the Secretaries of State, who are the policy holders, have framed the position in their written case, and I'm going to take the court to MS 3216 at paragraph 50, and there at 3A and B is set out on behalf of the Secretaries of State a position. I'm not going to read it out. I'm going to invite the court to
Which
cast an eye.
paragraph again?
I'm sorry, my lord.
Paragraph?
53.
50, subparagraph 3A and B.
B.
Thank you.
I don't need to read that. Yes. And while the court has been reading that, Mr. Rakeen characteristically has found an article in the publication Medicine, Healthcare and Philosophy, dating from 2005 by Bealby on the conflation of competence and capacity in English medical law. And so I have some hope that that will provide pickings. But I'm not going to go to it now. If I'm forgiven, we will provide that for the court. So we invite the court to note what the Secretary, what the official solicitor with respect considers to be the problematic juxtaposition that's set out in that passage between 2005 Act capacity and Gillick competence. If they're truly coterminous, then what practical purpose is there in seeking to maintain a separate common law approach to the test to adopt in the context of the delivery of care and treatment? Because having two coterminous tests with different routes would serve only to confuse practitioners as to which test to apply. On the other hand, if they're not coterminous, then which test should the professional apply, especially where it's not obvious that they would always produce the same answer? In this, it's clear that the official solicitor submits that the court should note that though there's a clear statutory presumption by Section 1.2 of the Mental Capacity Act in favour of capacity, and we'll give the court, without, I hope, needing to go to it, the reference in the authorities bundle, which is volume 1, tab 3, MS 60, there is no such equivalent presumption which can be spelled out from the common law test of Gillick competence. And that's where we do find there might be a dividing line. One approach...
The statutory presumption applies to 16-year-olds.
Yes. On one approach, therefore, the 16 to 17-year-old would have to assert and establish their own competence to consent to a particular act of care and treatment, whilst under the 2005 Act, the child would have the benefit of the statutory presumption. And one can certainly envisage circumstances in which that is a real difference. The official solicitor notes, in fairness, that the government has to date appeared to proceed on the basis that there is a statutory presumption of mental capacity post age 16. And in the authorities bundle, and I'm going to take the court to it, there is the Department of Health Reference Guide to Consent, dated 2004. That's volume 8, tab 92, at MS 2765. And there, my ladies and my lords, life appears, at least at first blush, to become more complicated by reference to Section 8 of the Family Law Reform Act, 1969. So can I invite my lords and my ladies and my lords to read paragraphs 2 to 4 inclusive on that page.
This is
2004
Department of Health's
Reference Guide to Consent, 2004.
we see the date 2004? I think it was 2009.
Let's see. I think my lady was, with respect, quite right, and we apologise for our error. We are 5 years out, so it's more modern.
But it has to be later than 2004 because it refers to the 2005 Act.
Indeed it does. Mr. Rutkeen, whose knowledge is encyclopedic, says, oh yes, this is the second edition. The first edition was 2004. Nevertheless, plainly this is the relevant one. As a sideways observation, my ladies and my lords will have noted that at paragraph 3, there's the observation, last sentence in paragraph 3, a young person may be able to consent to such an intervention under the standard of Gillick competence considered below, see paragraph 6 et sec. But if one looks at paragraph 6, that deals with what one might call young children. It doesn't deal, as does paragraph 4, with 16 to 17-year-olds. So, my ladies and my lords, we say that on a proper analysis, if the Secretaries of State agree that there's a presumption of mental capacity post-16, then the official solicitor, with respect, observes it's difficult to see on what basis they can now maintain Gillick competence can have any relevance at all post-16 in the context of medical treatment. We emphasise medical treatment. When set against the clear words of the 2005 Act, applicable to both to the provisions of Section 8 of the 1969 Act and more generally to acts in connection with care and treatment. We then come to another area of relative subtlety, which is, and my ladies and my lords will have seen it, the reference in paragraph 4 to the overwhelmed child, yet another category of child. And it's not a reference, we say, to the sort of circumstances considered in Gillick. If being overwhelmed signifies that there's a question mark about the ability of the child to give consent arising out of some fact outside the scope of the Mental Capacity Act, that is to say an impairment or disturbance in the functioning of mind and brain, the official solicitor submits that they can and should be addressed by the same approach as is applied to capacitous but vulnerable adults. Vulnerable adults is, in its broad use, a relatively modern concept. And
I'm not sure how helpful it's going to be to us, other than for the purpose that you've just used it,
yes.
Saying what the Secretary of State's position is, for us to try and construe paragraph 4, because
yes.
I read it as referring to the component in the statutory test which requires that to have capacity, a person must be able, firstly, to understand the basic relevant information, secondly, to retain that information, and thirdly, to use the information in order to make a decision. And I thought the overwhelmed child was one who wasn't able to use what the child knew because it was all so difficult. And in that case, it might be difficult to decide whether or not the child had the capacity but was not deciding, or didn't have the capacity. That's how I read paragraph 4. Not that it's a third category of child.
May I have a moment to see if we need to take that further?
You may not need to take it.
It may not
as I
be
say,
at all
we've got
helpful.
More fundamental.
Leave it? Yes, we'll leave it.
I rather got the impression Miss Lee agreed with me, but there we go.
We deal with these matters at paragraph 60 to 62 of our written case. I don't take my ladies and my lords to it, but I'll give the reference. It's MS 3125-6, and the reference also is to Riel, which I'm, again, in the circumstances, not going to take the court to, but the reference is Authorities Volume 4, tab 42, MS 1348, summarised in the head note at 1385, but I'm not going to pursue that. Yeah? But we say, for the avoidance of doubt, that the same approach should apply, not just to considering capacity to consent to acts in connection with care and treatment, but also to capacity to consent to acts amounting to a confinement, reminding myself, as I do throughout this case, that they are distinct matters of 16 to 17-year-olds. Maintaining a separate test of Gillick competence to consent to those specific acts is not, we submit, mandated by statute, and would, in practical terms, be a recipe for confusion. But, and it's an important caveat, we make clear that there are limits to the official solicitor's submission in relation to mental capacity. It's not an assertion that the 2005 Mental Capacity Act applies for the purpose of determining legal capacity to act of a 16 to 17-year-old across the board, because there is a wide range of things which statutory and common law provide for that 16, 17-year-olds can and cannot do, which, for example, 18-year-olds can do. Capacity to marry, capacity to vote. We have, of course, in those regards, a distinction within the United Kingdom, as this is the United Kingdom Supreme Court, but we are concerned with whatever the background progression may be, we are concerned with this particular England and Wales jurisdiction. Our point is a narrow one, that is, in answering the question of what basis a person delivering care and treatment, including acts amounting to confinement, is acting. The starting point, we say, in deciding whether the 16 to 17-year-old is able to consent should no longer be seen as Gillick competence, but should be defined in the terms of the 2000 Act. And the second basis on which the official solicitor relies upon the Mental Capacity Act as changing the context within which the court is invited to determine what the common law now provides is in relation to the basis upon which care and treatment is delivered to 16 or 17-year-olds who lack a capacity to consent. We've already posed the question, why do parental rights exist, and looked at it as of the time, 1985, when Gillick was decided. And then, we say, it was understood that it was necessary for a consent to be sought from a parent before a doctor could lawfully deliver treatment. Well, after Gillick, that assumption was to be looked at in another prism.
But only for people under the age of 16, because the Family Law Reform Act had already dealt with the 16 and 17-year-olds.
Yes, I'm reminded that the 1969 Act refers to circumstances where the person can consent.
That's right.
We're dealing with cases where they can't.
Sorry, I didn't understand that.
We are, of course, dealing with cases where people can't consent, but you were talking about...
Yes.
I understood what you were saying. But
my lady's background observation rightly draws me back from what would be an inaccurate generalisation.
Yeah.
Yes.
So your second point is that the 2005 Act changes the basis on which care and treatment is provided to 16 and 17-year-olds who are incapable
Yes.
of consenting to it. That's your proposition.
That is right.
And you're saying Section 5 takes
Yes.
over from whatever the other basis would have been.
Precisely so.
That's what you're saying.
Re-F in 1989 in the House of Lords, not going to take the court to it, but it's for reference at Volume 2, Tab 20, MS 536. The House of Lords recognised that the common law required reshaping to enable medical treatment to be given to an adult unable by reason of disability to consent to it. And that reshaping took the form of the reshaping of the defence of necessity. So that was the court acting. The defence didn't apply solely to acts of medical treatment, but also to broader acts of care carried out in relation to those lacking capacity to consent to what would otherwise be trespass to the person. But that was an adult case. Ultimately, the defence would be codified in Section 5, and we've already indicated to your lordships, my lady and my lords, the terms of that section, but if one looks at it, acts of care and treatment can now be carried out in relation to a 16 to 17-year-old lacking capacity without the consent of the parent, and if one looks at the code of practice for the operation of the 2005 Act, so I'm going to take, if I may, the court there, Volume 8, Tab 90, MS 2705, so the code of practice. I'm going to invite my ladies and my lords to read paragraphs 1216 to 1218. A practice guide is what we've termed soft law, but nevertheless, there it is. The official solicitor entirely accepts and indeed draws attention in his printed case, and I'm not going to take you, my ladies and my lords, there, but the reference is MS 3105, paragraph 11.3, to the fact that there was an anticipation that the 2005 Act would continue to coexist with the common law as it then, and we emphasize the word then, stood. This is provided for, although without any explanation as to when to choose which route to adopt in that code of practice at paragraph 1216. Whatever Parliament may have intended when bringing the 2005 Act into law, what no court has grappled with yet, so far as the official solicitor is aware, is the consequence of this codification of the defence of necessity in Section 5 and its applicability from age 16 onwards. Now, we did place that issue before the Court of Appeal in this case, but it wasn't engaged with in the judgment. We say the courts are entitled to look at the consequences of statutory enactment, and we say that in addition to parliamentary intention, and we certainly readily acknowledge that parliamentary intention or the lack of it can be looked at, and we say by analogy one can look at the case of ZH and the Commissioner of Police for the Metropolis. I'm going to take the court briefly to it. It's at volume 4, tab 38, MS 1268. It's a case in the criminal context, and although the context may be interesting and the court may find that reading of the paragraphs leading up to 44 on that page provides some background information for our part, it's paragraph 44 that we wish to draw attention to by analogy. A simple observation. For my part, I'm satisfied that where the provisions of the Mental Capacity Act 2005 apply, the common law defence of necessity has no application. We say that that's no more than common sense and a classical development of the common law, which can involve, with great respect, disposing of parts of the common law where there has been a statutory development. That was a first instance decision. The Court of Appeal upheld it in its entirety, but without considering this point, in fairness. And I'm certainly not going to take the court in those circumstances to what the Court of Appeal said. May I now take the court to an authority which may help to indicate why things are different in 2018 to the way they were at the time of Gillick, or what I might call a post-Gillick period. For that purpose, I will, if I may, take the court to volume 3, tab 21, MS 719. And the case of Bree E. in 1991. Putting it into context, it's after Gillick, it's well before the Human Rights Act, it's obviously before the Mental Capacity Act. The Children Act 1989 was well known, but at the time, I think I'm right, not quite in force.
It was not in force because the date of the decision was February 1991 and the Children Act came into force in October 1991.
Everyone was expecting it and preparing frantically, well, speaking for myself, for it, but it wasn't in force. So that's the context of time. And we say that in that case, to clarify the legal position of the parents, in particular the surgeon, the consent of the court was sought to carry out an hysterectomy on a 17-year-old girl with severe learning difficulties. The effect of that operation, of course, would be to sterilise Jay, the child, even if that was not the primary purpose. Jay's parents wanted to consent, but were uncertain as to whether they had the power so to do. And if I can take the court to MS 720, that's page 586. This is Stephen Brown, isn't it? Yeah. And this is the judgment of Sir Stephen Brown, the then president of the Family Division. There's a passage, if my ladies and my lords can see it, beginning, Jay's parents are quite certain. If one looks two-thirds of the way, or halfway down that paragraph, she's been made the subject of a wardship summons solely in order that the matter can come before the court. I say at once that in the light of the evidence before me and the very careful analysis of the position by the official solicitor, who's her guardian, it is clearly in the interests of Jay that this operation should be carried out. I've no doubt whatsoever about that fact, and if it's necessary for the court to grant its formal consent to the doctors and her parents for that operation to be carried out, the court will very willingly grant that consent. But that is not the purpose for which I'm drawing the court to that authority. At page 586, MS 720, Sir Stephen Brown described the anxiety on behalf of the medical profession about its legal position and possible legal liabilities, prompted by the decision of the House of Lords in F, to which I've already referred. And if I take my ladies and my lords to the passage at 587, Sir Stephen Brown agreed that clarity for the doctors should be important. So I'm going to draw the court, if I may, to the paragraph beginning, "It is important that the medical profession should." And Sir Stephen said he was satisfied after the careful analysis which Mr. Nichols, that's Mr. Michael Nichols, has presented to the court. There's a clear distinction to be made between cases where an operation is required for genuine therapeutic reasons and those where the operation is designed to achieve sterilisation. Again, not the point to which we draw the court. But having made reference to the speech of Lord Bridge of Harwich in F, the President went on to say, and I believe that it's the correct position in the present case, I think that Jay's parents are in a position to give a valid consent to the proposed operation. That is an operation which would achieve the sterilisation, that was not the primary intention, of a 17-year-old with learning difficulties. I'm not dealing in this case with the instance with the case of an adult. I am dealing with the case of a minor. Of course, he was. It's a person under 18. And it is plainly desirable that in order to relieve the particular symptoms of her distressing condition, Jay should undergo this particular treatment. Accordingly, in this case, I rule that the consent of the court is not required for this operation to be carried out. It's necessary for therapeutic reasons. In any event, if it were to be considered necessary, I would have no hesitation in granting the court's consent. So the view of the then President of the Family Division in 1991 was that such a procedure in such circumstances could be dealt with by way of parental consent, notwithstanding the consequences, notwithstanding age, notwithstanding learning difficulties. If one looks both in 1991 terms and contemporaneously at the concerns the doctors would have had, well, plainly they were entirely understandable. But we do say that 27 years after Re-F and 13 years after the passage into law of the Mental Capacity Act, it is with respect very unlikely that a court would give the same answer in the same situation to the approach of Sir Stephen Brown. Rather, we say unerringly, unerringly not in terms of us erring, but that's what the court would do. The answer would lie in the Section 5 of the Mental Capacity Act 2005, which exists to give certainty to professionals. If the doctors reasonably believed that J, the child in that case, lacked capacity and reasonably believed they were acting in her best interests, they could proceed protected from legal liability. The desire of J's parents to secure the interests of their daughter could be reflected in their input into the best interests decision-making process. Not only could, but would. They plainly have a locus. But the ultimate decision would, in legal terms, be constructed around J herself as the central actor, rather than her parents on the child's behalf. So we invite the court to return to the first question we asked, which is, why do parental rights exist at law in this context? And say, in the circumstances where it's now possible, following the Mental Capacity Act 2005, to carry out acts in connection with care and treatment in relation to an incapacitous 16 to 17-year-old without the need for parental consent, why, we ask rhetorically, is it necessary to continue linking the parental duty to seek treatment with the parental power to consent to that treatment? There isn't a utilitarian or practical link. The official solicitor submits simply that it's not necessary, and that this fundamentally changes the common law framework within parental rights and parental responsibility. That's the broad submission. Now we turn to look at consequences. And we ask our third question: what does confinement look like in relation to a 16 to 17-year-old? Now, a lot of this is likely to be familiar to at least some members of the court. And I'm going to take it relatively briefly. It's necessary to look first at what precisely confinement means in this context. Helpfully, all the parties and interveners agree that it means the first of the three limbs for testing whether a person is deprived of their liberty, as set out in the case of Stork. Now, Stork has had a long and interesting life in authorities, but we condense matters to paragraph 48 of our written case, which is MS 3120. Stork itself is in the authorities bundle, volume 1, tab 7, MS 289, but what I can do, because, as I said, this is relatively familiar territory and traversed in the written cases, is just to indicate with precision what Stork says. At paragraph 48, it's not Stork, that is yes, that document is. In our printed case, we say at paragraph 48, deprivation of liberty for the purposes of Article 5 of the Human Rights Convention consists of three elements, often called the three limbs of Stork. The objective element of a person's confinement in a particular restricted place for a non-negligible length of time, that's the first limb. Second limb, the subjective element of a lack of valid consent. So there's an objective element and a subjective element. And then the attribution of responsibility to the state. Those are the three limbs of Stork.
You'll give us the paragraph in the actual judgment in Stork which says that.
We will. Probably give it immediately, my lady. Perhaps not.
I don't think there's any dispute about it, but nevertheless, we prefer the original source.
Basic material, and it certainly outweighs the source which I've given you, my lady. Yes? Paragraph? Can I come back to that? I don't want to waste time.
Yeah.
Each of these three limbs has to be met for the circumstances to
I think it's paragraph 74.
Yes. Thank you, my lady. Slightly quicker, my lady, than Mr. Ruckeen. I'm very grateful. Each of these three limbs has to be met in order for circumstances to fall within the scope of Article 5 of the Human Rights Convention. If they are, then authority must be sought to authorise that deprivation of liberty on one of the grounds provided for in Article 5. And the Supreme Court has interpreted confinement in relation to those over 18 in the case of Cheshire West. There I can take the court, possibly relatively briefly, to Volume 1, Tab 5, MS 244.
Sorry, the reference again.
I'm so sorry. Volume 1, Tab 5,
Yes.
MS 244, which is to paragraphs 48 and 49 of the judgment of my lady, the President, Lady Hale. Might I invite the court just to read paragraphs 48 and 49 rather than my reading them out. for what has become known as the acid test. There is much to be gleaned from Cheshire West, but that might be for another day and another case, bearing in mind the limits of time that I have. But we will come back to Cheshire West and the judgment of Lord Kerr in a moment. So I invite the court to keep the reference open. The official solicitor and secretaries of state make common cause, we say, in submitting that the acid test should be nuanced in relation to a person under 18. The precise basis upon which they reach this conclusion differs, but the end result is, we say there's an agreement, and we make reference, I don't seek to go to it, to the Secretaries of State's written case at MS 3196, paragraph 10. The question to be asked in any given case is, first, whether the 16 or 17-year-old is subject to continuous supervision and control and not free to leave. And second, the constraints imposed upon the 16 to 17-year-old go beyond that which would be imposed on a child of the same age and relative maturity who is free from disability. So that's to be found in the Secretary of State's case. For support and authority for this proposition, we go back to Cheshire West, this time to MS 251, paragraphs 77 to 79. That's the judgment of Lord Kerr. And again, without reading it out, I invite my ladies and my lords to look at paragraphs 77 to 79, where that approach, we say, is set out in respect of the subjects Mig and Meg, as they're invariably known by those who cite the authority, although such were not their names.
Well, of course not. Well, can you think of an example, possibly I should ask the Secretary of State this, an example of being confined, so we're talking about a limited place for a not negligible period of time, in which you are under continuous supervision and control and not free to go, which would be normal for a normal 16 or 17-year-old?
Some aspects of school experience.
Thinking of detention at school.
I think of that constantly, my lady, owing to habituation. But yes,
Well, there are probably other things that you were habituated to in your
Lord, I
youth,
won't
Mr.
go there.
Setright.
But that's an obvious example. Of course, there are gradations to it.
Yeah.
And those who practice in public law care cases will know that the varieties of parental discipline know almost no bounds, and some parents will shut their children in cupboards or make them go into a room and confine them there. And there it's a question of degree. There's good parenting and there's bad parenting, but there are lines that are crossed. But school is a much more formal setting. So that's an example. I'm going to invite Mr. Rutkeen's thought of another one. Well, Mr. Rutkeen makes a mildly adversarial point. And he says that that's for the Secretary of State to deal with.
Well, I did say that possibly I should be asking
but
something.
he's really
But I
telling-
like it if you can produce an example,
He's-
because if you're agreeing with the Secretary of State, it's good
Yes.
to know why.
He's telling me I mustn't get lost in my script. But, my lady, we will try to think of other categories, and if appropriate in the reply, we might assist the court there. But it is possible.
Well, it would be helpful.
Yes, of course. Having thus traversed passages of Cheshire West, though I don't think we have seen the last of Cheshire West, we say that in terms of Nielsen, the debates which did occur in Cheshire West about precisely what Nielsen did and did not decide and how to allocate the case between the Stork trilogy, whilst interesting, we say they're probably rather sterile points. And we mention it, but the same might be said in respect to the controversy about how my Lady Hale treated the case of Nielsen in Cheshire West in circumstances where it was not an issue before the Supreme Court. There was an interesting debate before the President as to what my lady meant. I'm not sure it's necessary for me to go there because I don't think it bites upon what we're dealing with in this case. But no one is better placed than my lady to clarify. I'm not going to go there further, my lady. We think it's absolutely clear because my lady meant what she said. But there it is.
Which paragraph are we talking about for later reference?
We will provide, do you know? Can I come back to that, my lady? We addressed the position in Nielsen in relation to, in our written case, at paragraphs 52 to 3 at MS 3121. For reasons which I've given, we don't propose to go there now in detail. If necessary, we can in reply. Because our core submission is that Nielsen, properly analysed, is a case about the first limb of Stork. And we also say it's entirely consistent with the approach of Lord Kerr in Cheshire West, the primary factor leading the Strasbourg court to consider that the child Nielsen was not deprived of his liberty, was the fact that he was not subject to restrictions of a nature and degree similar to the cases of deprivation of liberty specified in Article 5.1, and we can give a particular reference. This is Cheshire West to Nielsen. A particular reference to Nielsen, I don't want to detain the court with it, which is Authorities Volume 1, Tab 6, MS 262, paragraph 62, which is on page 82, paragraph 72. Paragraph 72. And, my lady, the reference to your ladyship's observations is to be found at paragraph 39
Thank you.
of Cheshire West. How do I read that? Yes, having said that I wouldn't actually take my ladies and my lords to that authority, I think I probably, on reflection, should take the court to paragraph 72 and invite the court to read it on the reference I've given, in particular the words to be found in the last 6 lines of the paragraph, beginning in the line starting nature, and then indeed the restrictions to which the applicant was subject were no more than the normal requirements.
Which paragraph you?
72, my lady.
I think that's the pre-penultimate paragraph within 72.
Page
282.
MS 282.
282, thank you.
Mr. Setright, at the and later in 72, at the foot of the page, in our version, in the hard version, it seems to be referring more to parental consent, and indeed in 73, parental consent, again, features which might suggest that it was relating to the second limb.
What difference does it make which limb it relates to?
None, my lady.
No.
So our observation can just be put to one side.
But except that in this case, everyone's agreed that
Yes.
limb 1 is satisfied
That's
rather
right.
than about limb 2. So
That's right. No, yes.
we seem to be stuck with a distinction.
So we don't think that traversing Nielsen in detail is likely for the reasons which we've given to assist. Again, perhaps we can wait to see what the Secretaries of State and Birmingham say in their oral submissions, and if necessary and appropriate, we will seek to respond further. So we say, in other words, and to use the language from the later Stork case, the child Nielsen circumstances didn't cross the threshold for the first limb because we're concerned with the first limb from restrictions upon liberty to a confinement, and no Article 5 issues therefore arose in his mother seeking to bring those restrictions about in discharge of her parental obligations to secure the treatment she considered to be in his interests. We were tempted at this point to take my lady and my lords to the case of Guard, where relatively recently some similar but not perhaps entirely analogous considerations were arrived at. We've decided, in the interests of time saving, apart from anything else, not to, but we have considered Guard. We say that even if the court were to consider that Nielsen was about the second limb of Stork, which is the point that has been properly made to me, and even if the court were to accept that Strasbourg in 1988 took the view that a parent could consent to confinement of a 12-year-old child, the official solicitor submits that this could not be determinative of the position in 2018 in relation not to a 12-year-old, but to a 16 or 17-year-old, D being 17 as at the date of the hearing before Mr. Justice Kean. And we say that none of the Strasbourg cases to which the court's attention has been directed by Birmingham or the Secretaries of State address the position of older children, applying the reasoning of Nielsen. So we suggest, therefore, in anticipation, of course, of their oral submissions, that Birmingham and the Secretary of State can at most assert that if this case went to Strasbourg, which is not a suggestion remotely that it should, there is a paucity of directly referable Strasbourg authority. And the court might extend the logic of a controversial decision concerning a much younger child, predating such instruments as the United Nations Convention on the Rights of the Child, to find that D was not deprived of his liberty. But it's speculation to say what Strasbourg would make if it was faced with the same conundrum that is now before this court. When the limited nature of the observations from Strasbourg and the clear distinctions in the context with regard to age taken into consideration, we submit that it's clear that the Strasbourg observations can't sensibly stand in the way of the counter-indicators that we've taken the court to as to what we say is the current state of the English domestic law, which inevitably is the foundation upon which any Strasbourg consideration is built. So we don't dwell further on Nielsen or the Strasbourg cases. We will go back to it, either if the court would like us to, or if it arises out of submissions which follow these. So we go back to the first question that Stork requires to be answered, whether D was confined. Well, there's a concession that at all stages he was confined for the purposes of Limb 1. A correct concession with respect, says the official solicitor. The factual circumstances are set out at paragraphs 9 to 13 of the Statement of Facts and Issues, MS 3089 and 3091. Birmingham seeks to demur from the suggestion that this was secure accommodation. Secure accommodation, of course, as numbers of the court are aware, but others may not, is very much a technical term. Secure accommodation, presumably on the basis that Birmingham accepts that Dee's parents couldn't consent to his confinement in such accommodation. Secure accommodation, a creature recognised by the Children Act 1989, has about it a very careful and protective procedure. At paragraph 87 of that written case, reference...
But why does, I'm sorry, Mr. Sedgwick, but this actually is relevant.
Yes.
Why does the Children Act have a careful scheme of safeguards for placing children in secure accommodation, i.e. depriving them of their liberty? I think that's the definition, is it not, of
Yes.
secure accommodation?
Yes.
Why are there such safeguards, which mean that parents can't consent?
Milady,
Might it be because somebody thought that Article 5 required it?
there's certainly at least one person in this court who could probably answer that question. But I was going to provide what is not a facetious answer, because it was plainly necessary. It was plainly necessary, bearing in mind the gravity of the intervention, which, looked at in some ways, it has analogous consequences to a criminal detention. Nothing of that kind would take place without a court intervention. And Milady, yes, that human rights and other statutes, other domestic statutes, as well as a modern, in 1989, understanding of the position of children.
The safeguards for secure accommodation were introduced before the 1989 Act.
They were.
For different reasons. They were simply transported
Yes.
into the 1989 Act. It would be quite useful.
Milady, can we look at that and provide such assistance? I suspect limited assistance in terms of broadening the knowledge of Milady, but assistance generally...
Well, you might be drawing things to my memory, which I...
We might. Let us do that if we may.
I'm sorry, but if it was thought necessary to introduce safeguards which meant that parents couldn't consent to one form of confinement, why is it not thought necessary to have safeguards on the basis that parents can't consent to another one?
And inevitably, of course, and I'm doing myself down by rambling here, which I'll stop. It does already involve a public authority. There's a public authority already engaged, even if the secure accommodation order is made in conjunction with a first public law application.
Public authority is involved in this case.
But a public law authority is involved in this case. So that isn't the answer.
No.
And
indeed, would one be more or less worried
Yes.
about a parent consenting to a child being locked up by somebody else?
Yes. Where there might not be the very careful safeguards, structured safeguards, which exist in secure accommodation in the public law children setting. May we come back to that and provide information?
I am sorry for raising all these questions, but
No,
But
Milady.
Section 25 is
Yes.
in relation to a very specific category of children. It's children who are being looked after by a local authority. And at that point, you stop thinking quite in so much in terms of parental consent as
Yes.
you would do.
Yes.
And then there are all sorts of questions about the ending of the regime of care orders and the ages, because we're right in the area where certain remedies are not available, where orders start to expire and so on. It's quite complex, isn't it?
But
certainly
Section 25 does apply to all looked after children, including Section 20 children.
Yes.
It does.
So
That's why I'm cautious.
it clearly means that parents can't consent.
It does. And that's the broad submission that we make, though undoubtedly, my lady, Lady Black is right. There is a considerable complexity to the situation, as anyone who's ever done a complex secure accommodation order case knows well. May I depart from that for the moment?
Yes, of course.
And go back to my script. And so, where was I? The reality, we say, is that this was, and here I draw an analogy, controversial or otherwise, what has happened to D was, to all intents and purposes, secure accommodation designed therapeutically to contain him. So is there a practical difference? D lacked the capacity, applying the Mental Capacity Act, to consent either to be accommodated there or, more materially, to the restrictions upon him. We therefore turn to our fourth question: should D's parents be able to consent to those arrangements, thereby taking him out of the scope of Article 5 and its procedural protections? So that's our question. Should a parent in 2018 be able to consent to the confinement of a 16 or 17-year-old lacking the ability to consent to that confinement, which is D's case? We say quite simply that the time has arrived where the court can and should, with respect, mould the common law to reflect social and legal developments, including the passage of the 2005 Act, including the international conventions addressed by the Equalities and Human Rights Commission, to recognise that it is primarily not to the parents, but to the 16 or 17-year-old themselves that we must look. They are the principal actor. If the 16 to 17-year-old cannot consent to a confinement, and if it's imputable to the state, then that confinement should be recognised for what it is, a deprivation of that child's liberty, that it's brought about by parents seeking to do their best for their child. And again, I emphasise at this public hearing, nothing in what the official solicitor says is intended to criticise or undervalue the role of parents who have a say and who plainly, in a high proportion of cases, will want the best for their child and will be extremely anxious to secure it. But not all parents, and therefore it's likely but not inevitable that what the parents seek to do will be in their child's best interests. It doesn't mean that the parent, by purporting to consent, should be able to prevent what is done being recognised as a deprivation of liberty. So this is a submission which is really a statement of principle. And we can do that because there's an absence of appellate of authority, apart, of course, from the judgment of the President, which is subject to, and the Court of Appeal, which is subject to this appeal. And so this court can and should look at first principles. If the court wants us to trace through how the common law and codes of practice have already substantially limited the ability of parents to consent to serious interventions in the lives of older children, irrespective of the benign nature of parental motives, well, we've set that out. We've set out references, MS 3130 at paragraph 64.5, including by footnote, of our written case. I won't, if I'm permitted, lose the thrust of these submissions by taking the court to what there is set out as matters of detail. But if I may, we'll go on.
I'm sorry, the
65.4, my lady, on page MS 3130. And there's a footnote to that page. And the lady, it's the sentence in the text. In the circumstances, the official solicitor respectfully submits. And we make reference, misleadingly, I'm afraid, to the 2004 reference guide and the 2015 edition of the Mental Health Act Code. And there are some footnotes to our bland observation: the courts have recognised this good practice in a range of contexts. If I may, I will proceed to our fifth question, which is what relevance do statutory provisions in relation to looked after children have? Because that is a point made with emphasis by the local authority and by the Secretaries of State. And we say that it's not clear to us, it will become clear no doubt, whether Birmingham and the Secretaries of State say that the looked after children framework, in the parlance of the public law children practitioner, the LAC framework, means that there's no deprivation of liberty in the first place, or that the framework provides the necessary lawful authority for any deprivation of liberty to which the child is subject. Logically, given that both seek to uphold the judgment of the Court of Appeal, it must be that they seek to contend for the former. And I can give you, my ladies and my lords, the reference to the LAC framework. In Birmingham's case, it's MS 3154 to 3156, and in the Secretaries of State's case, it's MS 3224 to 3225. We say that whatever their position, there are a number of reasons why the LAC framework provides no answers or no adequate answers to the issues in this case. And the first is that this is in reality analogous to the arguments already made unsuccessfully by the government to the Court of Appeal in the Staffordshire case known as SRK, and the government there being the Secretary of State for Justice. That's why it was not necessary that private confinements be considered a deprivation of liberty, because there were sufficient safeguards in the system to ensure that poor quality care was identified. Now, that is the case that I alluded to early on, where it's not in the bundle. This we refer to in response, so we can hand up, and my learned friends are all fully equipped with this, some copies of Staffordshire County Council and Kay and others, 2016 EWCA Civ 1317, and we are in particular concerned with the judgment of the Master of the Rolls, Sir Terence Etherton. I'm going to take the court to particular sections in this report. First, at 281, E to G. I understand that not enough copies have been provided. I'll pause for a moment. Yes, thank you. 281, E to G, which summarises the Secretary of State's arguments. And I invite the court to look through those arguments, which are 281 E to G, and one sees a similarity on the face of it with the approach that's being deployed before the court in this case.
Though in the context of an adult.
though in a different context, of course. And if one wants to look at what was said about safeguards by the Secretary of State, that's at 282G to 283C. And again, it's, although plainly not a reference to the lack provisions, because it's adults, the theme is very similar. But importantly, in the context of deprivation of liberty. And so, having set the scene as to what the Secretary of State was saying, what did the court do? The arguments of the Secretary of State as to the adequacy of the relevant checks as an answer to the prior question of whether the person concerned should be seen as subject to a deprivation of liberty were dismissed by Sir Terence Etherton. And in the interests of time, I can take the court to the head note, but in full, there are paragraphs 74 to 75 on page 299. The head note, 279A, makes it clear that those arguments are not accepted. Dismissing the appeal, the state's positive obligation under Article 5.1 of the Human Rights Convention to take reasonable steps to prevent arbitrary deprivation of liberty, not discharged by the Commission in respect to care given by carers in an individual's private home, the current regime of law not sufficient to discharge that obligation, because the persons concerned would only act if someone had drawn concerns as to that particular person's care and support to their attention, which could be particularly problematic where no family members were involved, but similarly criminal and civil law sanctions which operated retrospectively were insufficient to discharge the positive obligation. The same themes with great respect. Even if it were to be said that the LAC regime was, in practical terms, a model of proactive, outward-looking effectiveness, the same observations apply to this case. We say that that authority is helpful in indicating that there are at the least limits to reliance upon relatively passive background safeguards when looking at acute decision-making, which can take place against the background both of a need for speed and a high emotive element, and may require great proactivity. We draw attention to the practical difficulties particularly involved when looking at children, 16 to 17-year-olds, who themselves are by definition in very difficult circumstances. If it is said, well, the children could themselves bring the matter to the attention of a court if they wished to challenge, or that, for example, an independent reporting officer could bring matters to the attention of a court if she or he felt there was a need. The practical deficiencies of that, compared with the proposal which the official solicitor puts forward for these difficult cases, are, with great respect, obvious.
Was there any attempt to appeal to this court in Staffordshire?
We'll look at that. I don't believe there was.
No, it doesn't ring any bells with me,
No,
but then I don't see all the
I
applications.
don't think there was. And I suppose I should take my lady and my lords to, for completeness, paragraphs 74 and 75 of the judgment of Sir Terence Etherton. And invite the court to read those short paragraphs. 75 being a broad statement.
You've been referring to the LAC regime, but that only happens where a child is being looked after, and we're in the very difficult area of 16 and 17-year-olds. I can't immediately find the answer to this. I know that the restrictions in Section 31 of the Children Act on seeking care orders in relation to older children, 17 or 16 if married, but what about the emergency protection order and other emergency provisions? I can't readily find the answer to the age limits on those, and that might be helpful.
May we look at that? But my lady presages where these submissions are going to go now. We say that the arguments of adequacy run before this court now should be dismissed much as they were in SRK, because they conflate the question of whether what is being done is, in parenthesis, the right thing, which it may very well be, with the question of whether the person in question is in fact deprived of their liberty. No one disputes that G's confinement was necessary, and he remains confined for completeness in much the same circumstances, age 19, today, that it was proportionate in his best interests, as in the cases of Mig and Meg before the Supreme Court in Cheshire West. But that shouldn't divert the court from recognising that the confinement amounted to a deprivation of liberty. And to the extent that it said that including D and his like within the scope of Article 5 would be to impose undue and unnecessary burdens, we say that's inapposite. The Secretary of State for Education, as the policyholder, suggests that the checking of whether the consent being given by the person with PR to the confinement of the child is a scrupulous one, and that this will entail a practical obligation to ensure conscientious and careful scrutiny in each individual case by relevant personnel from the local authority. And the reference there is MS 3222, paragraph, is that right? 3222. Yes, 3222, paragraph 60 onwards. One might query whether these observations go further than can legitimately be extracted from the relevant statutory provisions. I'm not going to go into the detail now, but we may in our reply. Taken at face value, those operating the current system are under an obligation, if it's to work, to interrogate precisely what factors have been in the parents' minds when consenting to the confinement of their child. Just putting it in that way indicates where a difficulty lies. In particular, where the views of, this means that the official will be scrutinising materially identical matters, in particular the views of the 16 or 17-year-old and the nature of the restrictions, to those that they would be looking at if they were considering the question of whether to seek authority for a deprivation of liberty from another source, by the route of the primary case for the official solicitor. It's for the government to decide, because there's been an indication that legislation is contemplated, it's for the government to decide whether to implement the Law Commission's recommendations to enable administrative authorisation of deprivation of liberty for those in this position. And we say that
currently, what we refer to as the DOLs,
yes,
in other words, a different set of safeguards for the deprivation of liberty of incapacitated persons without having to go to court, don't apply to 16 and 17-year-olds, do they?
that's right.
Yes. And that's interesting in itself, and maybe there's some explanation as to why that is the case.
If, on the one hand, 16 to 16 and 17-year-olds are in some ways being treated as adults, but not this way. Not
Sorry,
expressly.
where does one find the scope of the dolls in relation to 16 and 17? I should know what I do.
Can I come
It's the
back?
age requirement in
Yes.
Schedule A1.
Yes.
Thank you.
I think, is it in the bundle?
I think,
It is
Schedule
in
A1?
the bundle. We'll give a reference.
Yeah. Well, I found it.
I'm very grateful.
It is here.
Yes. But we say that the LAC system, by definition, and this is precisely my Lady Black's point, does not apply to save to children falling within its scope. That is to say, looked after children. And importantly, it doesn't apply to all children who might be deprived of their liberty in other settings or circumstances. For example, it wouldn't automatically apply in relation to the admission of a 16 to 17-year-old into confinement in a psychiatric institution. Such could take place on the say-so of a person with parental responsibility. That person would then fall to be treated as an informal patient for the purposes of the Mental Health Act, attracting none of the procedural safeguards. That's on the basis of put forward by the Secretaries of State. Moreover, even if the LAC system did apply, it doesn't address the point of principle in this case, we say. Rather than traversing in these oral submissions at this stage the functions of the independent reviewing officer under Section 35B of the Children Act and regulations 36 and 45 of the Care Planning and Care Review Regulations, I'm citing those to indicate the framework and that we have given consideration to them, of the Care Planning and Care Review Regulations, and responding in detail at this stage to the points made by Birmingham in its written case, we make the overall submission so that our position is clear to the advocates in this case that none of the functions being discharged by those under LAC are designed to answer the question of whether or not the child in question is deprived of their liberty. And we reserve our position until after we've heard the way the case is put to respond as to our possible reply, or if necessary, because time is limited for everyone in this case, seeking to agree a detailed technical note for the court on these rather intricate matters. But we note at this stage that it appears there's no dispute that if D was deprived of his liberty, nothing in LAC would obviate the need for authority to be sought for that deprivation of liberty by a court, which is the basic point. Therefore, we say LAC is an imperfect, patchy and partial safeguard. Even if operated in the fashion contended by the Secretaries of State, it's insufficient to answer the point of principle in the case because it doesn't answer the question. It is also, we say, manifestly inferior in practical protective terms and in terms of respecting the position of the child to that which is proposed by the official solicitor. Well, now, I said I was going to address the court on 6 questions, and we've come to question 6, and it's also 1:45. And the 6th question was, how should decisions in relation to care and treatment of 16 and 17-year-olds with impaired capacity be taken? Well, what I think I'm going to do, rather than traversing some rather detailed submissions orally, is that I'm going to refer the court, where's paragraph 66, what's the reference? Thank you. To MS 3131, which is where we deal with these matters in our written case, where we make certain proposals set out at 66, 1, 2, 3, 4,
Well, you have until 1 o'clock.
I know, but I'm not...
You've got something else you want to
Sadly,
do.
the questions are not the end. And there, don't I? Yeah. Do I go to that? Yes. And in our remaining time, at this stage, what I should probably do is to make reference to what we term our alternative case.
Just before you do that,
Yes, of course.
Can I ask a very quick question? On page 3131, you've laid emphasis on the fact that the parents' views as to how the child should receive treatment would be taken into account and given weight. But I don't see that in paragraph 66. Have I missed something? Is it implicit in something which you explicitly?
If it isn't there, it most certainly should be.
Yes, it is an important factor.
It's a vital factor, because looking at what we say is not only a legislative background, but also at human rights considerations and statutes. There is today an emphasis not only on children as actors, particularly older children, and the rights that are imputed to them and the respect given to those rights, but very much done without derogating from the respect given to parents. And nothing in the official solicitor's case is designed to undercut that. In a sense, if I can be forgiven, and on my own head be it in terms of timing, the position of parents is enhanced by this, because in what are acutely difficult circumstances, they will be given a formal framework in which they can not only give their views, but challenge and canvass the views of others, have access, where appropriate, to professional opinion where that is engaged in the case, and deal with matters not in an informal way, but in a formal way, so that they will know, first, that they've had their input, they've had their say, and second, that they will see a transparent process.
Well, perhaps one answer to my lady's question is Section 4 of the Mental Capacity Act.
Yes, absolutely so.
Which basically provides the methodology for making decisions in the best interests
Yes.
of P, that is the
Yes.
person who lacks
There's a
capacity.
checklist.
That's the
Yes.
methodology,
Yes.
and that would obviously include considerable input from the parents
That is
into
out.
that.
And that is set out, MS 3105, at paragraph 11.3 in our written case.
And you would find it on page 62.
Yes, just so. I now will, if I may, having not quite avoided question 6, but I'm very grateful for the question from my lady, Lady Ardens, and my lady, Lady Hale. Will my lady give me a moment? What is this? Do I want that in this? Oh yes, I suppose so. Yeah. We don't have it here. And just in further answer to my lady from the oracle next to me, there is a case called Tracy, we haven't got it here, we can provide it, which shows that there can be a liability if a parent is not consulted with. So, but my lady, in any event, it's a given in any proceedings of this kind, and it really is tremendously important. So, page 38 of my note, of no use to my lady and my lords, but our alternative case, if the court is not persuaded to take what is the bolder course, but we say the logical course, of revising the common law and making the centre the 2005 Act, then the alternative proposal is that if parental consent remains valid then the court should seek to require parents, insofar as is possible, to apply the checklist contained in Section 4 of the 2005 Act. Well, there's a logic to that. The logic, however, quickly, we say, runs into difficulties, because how on earth does one do that? The checklist is obviously in the bundle, Volume 1, Tab 3, MS 61 to 62. Not only would the parents have to consider the checklist criteria, they would also have to consider, in the context of deprivation of liberty, whether the restrictions were necessary or proportionate. Now, of course, a lot of parents would do that. One need only think of an informed parent with high intelligence, a careful scientific approach, as well as an emotional approach to the commitment of childcare, who might well ask all those questions anyway. But among the cohort of parents whose children get into a situation where, unfortunately, deprivation of liberty it turns out to be something that needs to be canvassed, there will be an enormous number of parents who are quite simply not equipped in this way, possibly the majority, because it is challenging to a professional to look carefully at these criteria and the balancing exercise. We say with great respect, a court is well equipped to deal with these matters, and sometimes a court can find dealing with them taxing and emotionally draining. The official solicitor recognises that any person relying on the consent of the parents would have to satisfy themselves that the parent had considered these factors. How is that done unless it's a more or less empty box-ticking exercise, which is not a good way to protect a child? The official solicitor recognises that it would be entirely unrealistic to expect parents to have Section 4 at their fingertips, any more than one expects a parent to look at the welfare checklist in Section 1.3 of the Children Act when looking at making day-to-day, even important day-to-day, care decisions in respect of children. But the difference is we are talking of a deprivation of liberty. What is important is that the parents have considered the factors in substance. We recognise that the form, rather than the substance, is not really important. We note, by analogy, that this is exactly what is required of professionals seeking to rely on Section 5, and we make the reference to the authority we've already drawn the court to, ZH and the Commissioner of Police for the Metropolis, where an indication at paragraph 40 in the judgment was provided at what the police would have to deal with. And as we set out in our written case, MS 3132, paragraphs 68 to 69, we suggest that it's important always to be clear that any consent being given by a parent is not to be seen as a consent on behalf of the child. And that goes back to what parental responsibility is. It is the parent's consent. It isn't the child's consent. I don't wish to retrace our steps, but it's troubling in 2018 in the sort of context that we're considering, that there might be that confusion. And we say that rather the parental consent is authority to relevant individuals to carry out any relevant non-negligent act in relation to the 16 or 17-year-old without attracting criminal or civil liability. We say that's for two reasons. First, it's both invidious and wrong, we submit, to pretend that a 16 or 17-year-old who may in fact be vigorously objecting to the relevant act should be seen as consenting to the same act via her or his parent. And although I don't wish to make too much of it, it is the plain fact on the evidence that D himself in this case escaped from his detention. He plainly didn't want to be there. And second, that adopting this approach would replicate as far as is possible, the approach adopted in Section 5 of the Mental Capacity Act 2005, which provides authority to act where the relevant conditions are satisfied, but does not purport to represent consent being given by the individual. We say there appears to be an agreement. We'll find out whether I'm right in this afternoon, between the official solicitor Birmingham and the Secretaries of State as to who could, in principle, exercise a power to consent, individual persons. I promised we'd come back to that, because even if there's agreement, it's the question why that deserves to be answered. We don't address, the Secretary of State doesn't address the official solicitor's alternative case. The Secretaries of State concentrate on the first line case. Birmingham seeks to dismiss it on the basis that it doesn't in fact add anything material either to its case or to that set out by the courts below. Indeed, there's an inference in Birmingham's case that we shouldn't really be raising it at all. But we say it's entirely logical and necessary that we are, if we're to assist the court in doing what the official solicitor believes needs to be done, which is taking a look at the broad landscape and deciding what the options are, what the choices are, and looking at them in terms of appropriateness and adequacy. And we say that, with great respect, reliance upon the looked after child regime is, for reasons which we've given, and may elaborate in our reply, to miss the point. If the court is to adopt a regime, is to say that there should be a regime which retains effective parental consent, then we submit that the court should come as close as it can to replicating the structured decision-making process imposed under the Mental Capacity Act, Section 5, including perhaps with reference to Section 4, which seeks to construct a decision on behalf of a person of impaired capacity, working from them upwards and outwards. My ladies and my lords, can I just turn to those around me to see where to now? Some stage. Anything else? Anything else? My ladies and my lords, for all those reasons, we submit that on the facts of this particular case and this particular circumstance, it is plain that the Court of Appeal was wrong to find that D's parents could consent to the confinement to which he was subject, without, as I said, for a moment indicating that it was wrong that he should be confined. They were wrong in our primary case because they could not appropriately, as a matter of law, give that consent. Doesn't devalue the fact that they rightly felt that it should happen. They were wrong, were the Court of Appeal, we say, with respect on our alternative case, because the arrangements went very substantially beyond the scope of any arrangement which society in 2018 would expect that they should be able to authorize by the exercise of a common law parental responsibility. My ladies and my lords, those slightly condensed, and I'm very grateful for the indulgence in the court in my avoidance of giving detailed answers to some questions. Those are our oral submissions. We have been asked some specific questions. May we come back in an appropriate way on those with some answers?
Of course you may.
Thank you.
Thank you very much indeed, Mr. Setright. Mr. Ratkeen?
No, my lady.
Well, you are, by my clock, 2 minutes ahead of time. But we won't get Mr. Wolfe to his feet. We will adjourn and look forward to hearing from you further at 2:00.